5 things you should know about contesting a will. Number 1, what kind of action do you potentially have? There are many different forms of estate litigation that will achieve a client's outcome, but will depend on the individual facts and circumstances as to what form of litigation you can pursue. For example, if you've been left out of a will or been named in a will but not received what you think that you're entitled to, then you can bring a claim for what they call further and better provision from the estate. Although, if you think the deceased person did not have capacity when they made the will, you can challenge the validity of the will. In these examples, the procedure to prosecute your claim is very different. During our free claim assessment, we will spend the time to understand your side of the story so we can determine what type of litigation to pursue and then implement a strategy to achieve your desired result. Number 2, how long do I have to take action? Time limits apply to most legal actions, and estate disputes is no exception. In most cases in Queensland, you have 6 months from the date of death to give the executor notice of your intention to claim against the estate, and then 9 months from the date of death to commence proceedings in court. If you are challenging the validity of a deceased will, so you think that they did not have capacity to sign the will, or there was undue influence when they signed the will, for example, you have to lodge a caveat in the Supreme Court. There's no specific time frame in this regard, but it should be done as soon as possible before the executor obtains probate. Number 3, who pays the legal costs of challenging or contesting a will? On most occasions, the parties' legal costs are paid from the estate. Generally, it is only a claim that is baseless or without merit that the legal costs will not be paid from the estate. Early in our free claim no obligation assessment, we will provide detailed consideration to your position and the merits of your claim before we commence proceedings, so you are fully aware of what to expect. Number 4, I'm part of a blended family. Does that matter? The simple answer is no. The traditional family is less common these days, and blended families are on the rise. And a blended family is generally where a spouse starts a relationship with a children or child from a previous relationship. The law has recognised this and allows stepchildren to claim from step-parents' estates. Given that only about half of all Australian adults have a will, the risk of litigation in blended families is normally very high and often leads to disputes. Number 5, do I have to go to court to challenge or contest a will? The short answer is no. In most cases, it is beneficial to try and settle the dispute prior to going to court. However, if a party is being unreasonable, the court may need to intervene, which can result in the unreasonable party being ordered to pay some or all of the legal costs of the other side. Most will disputes settle before the need to have a trial in court. Where appropriate, we attempt to settle a will dispute without the need for the court's intervention, so we can minimise the legal costs, which will only diminish the estate, so there's more for all parties involved. Please contact us for a free, no obligation claim assessment.